Good afternoon, and welcome to the Vleck Constitutional Law Moot Court Competition. Thank you all for joining us today. In a moment, we're going to begin the oral argument, but before we do that, I just want to say a few words of introduction to our very distinguished jurists who will be joining us. I think when you hear their credentials, you'll realize that we're very privileged to be in a legal profession that recognizes its finest, its best and its brightest, and elevates them to positions of responsibility, such as the ones that are held by these judges. Our Chief Justice today, will be Sonia Sotomayor of the United States Supreme Court. Justice Sotomayor graduated summa cum laude from Princeton. She graduated from Yale Law School. She served as an assistant district attorney in New York, a partner in a major New York law firm, before being appointed to the U.S. District Court. She was later elevated to the U.S. Court of Appeals for the Second Circuit, and now is a justice on the United States Supreme Court. I encourage you all to read her best-selling book, My Beloved World. It's an autobiographical account, and I think it's very inspiring. We will also be joined by Chief Judge Robert Katzmann of the U.S. Court of Appeals for the Second Circuit. He graduated summa cum laude from Columbia, obtained his master's and his PhD in government from Harvard University. He also was a graduate of Yale Law School. He was affiliated with the Brookings Institute for many years before being appointed to the Second Circuit, where he is now the Chief Judge. Our third judge is U.S. District Court Lee Rosenthal of the Southern District of Texas. She's a graduate of the University of Chicago, both an undergraduate and law school. She clerked on the Fifth Circuit, was a partner in a major law firm in Houston, and has been a judge on the U.S. District Court for over 20 years. We'll begin the oral argument, and after the oral argument is over, we'll have a period of intermission while the judges deliberate, and during that time, we'll introduce to you the contestants, and we'll also give out some awards. So that'll sort of be the halftime show. We'll begin immediately after that. Let me remind you that this is a very dignified and important event here. Please show the judges all the decorum that you would show them in a real courtroom. And let me remind everybody to please silence your cell phones. And with that, let the argument begin. Thank you very much.
All rise. The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. Counsel, are we ready? Petitioner?
Madam Chief Justice, may it please the court, good afternoon, Your Honors. My name is Amanda Nagrotsky, and along with my co-counsel, Olivia Jahn, we represent the petitioners in this matter, Mr. Buzz Alden and Miss Betty Eddy. Before we begin, the petitioners request 2 minutes for rebuttal.
Granted.
The government began its investigation by obtaining, without a warrant, 2 months of Mr. Alden's cell phone GPS locations. Not content with this sweeping invasion of Mr. Alden's privacy, the government insisted on actively tracing Mr. Alden's GPS locations for another 2 weeks, pinging his cell phone 917 times.
Can I ask you a question about the way this all works?
Yes, Your Honor.
The CSL data, if your cell phone is on, but you're not having a phone call, what, if anything, is collected?
Your Honor, when your cell phone is turned on, that can register in terms of cell site location data. When a cell phone is turned on, it registers with different cell phone towers to obtain a signal. So that information was within Mr. Alden's cell site location data, or it would be within typical cell site location data. We submit that the warrantless pinging of Mr. Alden's phone violated his reasonable expectation of privacy. By pinging Mr. Alden's phone...
Well, didn't the cell phone provider keep those records? That's how they got provided to the government, correct?
In terms of the pinging, no, Your Honor. In terms of the cell site location data, yes.
But why should that make any difference? I mean, one is historical, one is real time, but in terms of the detail and the type of information collected, Isn't it equivalent?
Yes, Your Honor. However, to the extent that the government relies on the third-party doctrine, it cannot apply to the affirmative pinging of Mr. Alden's phone. Horizon Wireless did not ping Mr. Alden in its ordinary course of business, but for the government's request to ping Mr. Alden's phone, Horizon Wireless would not have done so once, let alone 917 times.
What do the pings, is it when you say ping, is it the data that's collected and stored in CSL?
No,
Is
Your
it
Honor.
just intervening so you see that data instantaneously rather than waiting for it to be generated in the
That's
regular
correct, Your
course?
Honor. By pinging Mr. Alden's phone, law enforcement was able to get an update on Mr. Alden's real-time GPS locations, and we submit that this was an unconstitutional search.
Let's go back to the third-party doctrine. How is this different than a pen register, which we have held as constitutional? We've said telephone numbers are not private information. You give them out freely. You walk out into the public with a cell phone, anybody could see where you are. So why is this any different than the pen register?
Your Honor, in Smith v. Maryland, this court did focus on the limited capabilities of the pen register. While Mr. Alden's cell site location data did not reveal the contents of his communications like the wiretap did in Katz, it still revealed the contents of his life. It was still a massive invasion of Mr. Alden's privacy.
Let me give you this scenario, just sort of following up. So let's say that the defendant had a GPS-enabled exercise tracker that carefully recorded every place that he went for 2 months in order to help him calculate the number of calories that he burned in a day. And so imagine that he gave that exercise tracker with the associated GPS data to his personal trainer, and the personal trainer then handed it over to the government. Wouldn't the third-party doctrine clearly apply in that context?
No, Your Honor, not necessarily. The third-party doctrine is a manifestation of what society accepts as reasonable, what society is willing to accept as reasonable. It does not cover every piece of information that is conveyed to a third party.
But in the scenario that I gave you, wouldn't the third-party doctrine apply? Because here, the individual is voluntarily wanting to, have this data collected. Why isn't that the same kind of scenario as that where the third-party doctrine applies?
Well, Your Honor, in terms of your hypothetical, a critical distinction between your hypothetical and the case here is that with an exercise tracker, I imagine that would be used to track an individual as he runs around outside or in a public place. But Mr. Alden's cell site location data, for example, was not used just to monitor his public movements, but his private movements as well. From the cell site location data, law enforcement was able to infer the location of Mr. Alden's apartment because it was where he could be found most nights. This implies...
Well, it didn't tell anyone that he was in the apartment. They told him, it revealed that he was in this building. It doesn't locate him within the building.
And it doesn't reveal anything about his activities or location within the apartment, does it?
It doesn't, Your Honor. However, in United States v. Caro, this court held that the Fourth Amendment prohibits the government from using an electronic device to determine that an individual is in his home and that he remains in his home. And that is precisely what the government did in this case when they pinged Mr. Alden's smartphone without a warrant and when they used his cell site location data to monitor him within a private residence.
Well, let me ask you a question about how you define where the limit of the reasonable expectation of privacy is, because you've urged us to look at that as a way of setting aside some of the third-party disclosure cases. If you look at the Stored Communications Act, it seems to allow law enforcement to get information other than the contents of cell phone calls, which would include location data, without showing probable cause. And there's no exclusionary remedy provided. Does that give us some indication about what at least Congress thinks is reasonably protectable
Yes, Your Honor, it would. However, because the Stored Communications Act lacks an exclusionary rule and a suppression remedy, and because the standard that law enforcement must meet to compel disclosure under Section 2703 of the Stored Communications Act, we submit that it is this court, not the legislature, that is in the best position to deal with the privacy issues raised by this case. And even if we...
That may be true, so let's go back to our cases. I don't know what greater sense of privacy people have than information about their financial situation. Most people don't tell people how much money they have in the bank. Yet we have permitted the disclosure by banks of people's deposit history. It's on the third-party theory that if you disclose it freely to someone, then there's no reason why the government should be excluded from that. So why should everybody on Facebook be able to read a posting and not the government because it hasn't been friended? It's the same concept. So explain to me your theory about reasonable expectation of privacy in light of our case law, because you just said, we define it.
Your Honor,
So haven't we?
Your Honor, I believe you're referring to United States versus Miller in terms of the bank records. However, Mr. Alden's business arrangement with Horizon Wireless, his service provider, cannot be compared to the bank's arrangement with the defendant in Miller. That arrangement involved the bank's need for the defendant's financial information because banks are responsible for ensuring the continued acceptance of negotiable instruments or checks. So banks in that case were a party to the transactions involved. They did have a substantial need in knowing the defendant's financial information. In this case, Horizon Wireless did not have a substantial need in knowing every location Mr. Alden had traveled to.
Oh, but they did, according to them. They had a business need. From the owner of the telephone, they got permission to do the tracking.
That's
So
correct.
they claim that they do it for the purpose of providing better products. Whatever their purpose, permission was given.
Your Honor is correct that it might be helpful for Horizon in terms of business purposes in knowing Mr. Alden's cell site location data. However, they did not have a substantial interest in knowing or maintaining a record of every public and private movement that Mr. Alden went to over the course of a 2-month period. This court should not only be concerned with the information that Mr. Alden's cell site location data explicitly conveyed to the government, but also with the negative inferences that law enforcement can draw from the aggregation of this data over an extended period of time.
So give me a rule, and what's the rule?
Your
The
Honor,
government is not going to be treated like a third party when? Meaning, if I've given permission to someone else, like the personal trainer, or I've given permission to the GPS company to keep it on and to track me, why shouldn't the government have access to that information? Why isn't it private?
Your Honor, we would respectfully request that this court reconsider the third-party doctrine's application and rationale to this case in light of the digital world that we live in, where a number of Americans convey a great deal of private information about themselves while carrying out ordinary
But
tasks.
how would you, it seems to me that you're suggesting that we need to change the way that doctrine is defined or applied. Referring back to the Chief Justice's question, what is the rule? How would you define or redefine this doctrine?
The third-party doctrine, Your
Third-party
Honor?
doctrine.
In terms of the technology used in this case, the advanced technology that enabled law enforcement to conduct persistent tracking over Mr. Alden for 2.5 months, we would ask that this court decline to apply the third-party doctrine to Mr. Alden's cell site location data. And I'd also like to point out that in Smith versus Maryland, this court focused on the defendant's knowing disclosure of the telephone numbers that he dialed and conveyed to the automated operator. And this court relied heavily on the log of long-distance phone calls to presume that Smith conveyed those numbers knowingly. But But in this case, when cell phone users receive their monthly bills, there is no log of the cell phone towers that their cell phones communicate with to make and receive phone calls.
But didn't his provider give him the opportunity to disable the location-based services that required the tracking and the ability of the company to collect that information? And do we simply ignore the fact that he opted not to do that?
Your Honor is correct that the license agreement between Mr. Alden and Horizon does contain a provision relating to what you just said. However, that license also states in bolded print that Mr. Alden's consent to Horizon's collection and use of his smartphone location data is predicated upon Mr. Alden's use of a location-based service, Google Maps or Facebook, for example. The record reveals no such instance in which Mr. Alden used any such service. The license also states that any data collected by Horizon would be in a form that does not personally identify Mr. Alden. So given the very misleading nature of this license, we ask that this court does not hold it against Mr. Alden in determining whether he had a subjective expectation of privacy in his cell phone data.
Let me ask you something. Are you taking or quarreling with the fact that he is bound by the owners, the cell phone owners' consent with respect to the tracking? Because you're sort of riding the line on this and saying he didn't consent. He didn't use Facebook or Google, or not Facebook, Google Maps or anything else. But did she, the owner?
There's no information in the record as to that, Your Honor. However, we know that Mr. Alden was the operator of this phone, and we are asking that this court...
So let's go back to the bank records. I'm going to assume that if someone shares with a bank information, that it's shared on condition that they use it for their business need. So if you share information with your service provider, you assume they're going to use it for their business needs. That's never restricted the third-party doctrine's application to disclosures to the government. Why should we do it here?
Your Honor, we ask that you do that here by considering the very invasive nature of this smartphone technology. We ask that this court decline to apply the third-party doctrine to Mr. Alden's cell site location data, because then virtually nothing will qualify as private. 91% of Americans own cell phones. So if this court is going to say that the third-party doctrine still has application in the digital world that we live in, the Fourth Amendment will be completely eviscerated.
But why isn't that slippery slope argument applicable to the earlier use of telephone numbers, to the earlier use of bank information, all of which disclose personal information, private information, but which this court has said, if you are dealing with it in a way that gives it to third parties, you can't turn around and say, oops, I get to keep that secret, unless there's a probable cause showing and a warrant obtained.
Your Honor, I see that I'm out of time. May I finish
Answer the
my
question.
Your Honor, the Fourth Amendment secures citizens in their persons and in their houses, and it must offer greater protection to Mr. Alden's smartphone location data, which allowed for tracking of his public and private movements, than it does to a mere business record. If the Fourth Amendment is to have any vitality in the digital world in which we now live, this court must adapt its Fourth Amendment jurisprudence accordingly to advances in technology, reverse the 13th Circuit, and hold that the warrantless use of Mr. Alden's smartphone location data violated the Fourth Amendment. Thank you, Your Honors.
Madam Chief Justice, may it please the Court. Good afternoon, Your Honors. My name is Olivia Jahn, and I represent the petitioners, Mr. Buzz Alden and Ms. Betty Eddy.
Counsel, should we treat the CSL data differently from the GPS ping data? And if so, why? How does that help you?
Your Honor, the difference between the CSL data and the GPS data is distinct in the fact that for Mr. Alden, as my co-counsel explained, he did not voluntarily convey anything through the pinging. When the government contacted Horizon Wireless to ping Mr. Alden's cell phone 917 times, that was a request on the part of the government specifically to track him for his every movement for 2 weeks. And through that information revealed very private information.
So how is this any different than a beeper in a car container
Well, Your Honor,
that a owner has placed in the container?
Well,
The
Your Hon-
owner of the phone has permitted the company to have technology that does this, had the option of saying no, and didn't. So how's this different than our case where we said that a beeper in a container placed in a car was legal?
Well, for example, Your Honor, the important distinction between Knotts and Caro is that in Knotts, this court, the government, police enforcement in that case, stopped tracking the defendant when he reached the home, as opposed to in Caro, where the distinction there, the court found that search unconstitutional because the government continued to track him when the beeper was in the home, and the fact that it remained there and the government's knowing that the beeper remained in the home was unconstitutional.
How's that different from a police officer sitting outside and watching him go in and watching until he came out?
It's different, Your Honor, because it revealed information about the home, the fact that the beeper in that case remained in the home. And I think this is an important information to segue into the second issue before this court today.
I'm not sure, well, I mean, a house is a house, so you know if he doesn't come out the door that he's in the house. And the tracker does nothing different than tell you he's in the house. It doesn't tell you in what room. It doesn't tell you whether if it's an apartment building, if he's visiting a different apartment. So I'm not quite sure what the difference is.
The difference is, Your Honor, is that the government in Caro was able to determine that the beeper remained in the home, just like the cell phone in this case revealed to the government that Mr. Alden entered into Miss Eddy's home and remained there through its pinging. And this is my segue into the second issue before this court today.
But the record indicates that the government sent 917 ping requests. That amounts to, my math isn't always that good, but I believe it's a ping every 20 minutes or
Yes, Your
30
Honor.
minutes. Doesn't that frequency raise concerns about the ability of the government to constantly track the location of any person with a cell phone without any warrant at any time?
Yes, Your Honor, that is exactly what happens. That was when the government pinged Mr. Alden's cell phone 917 times. It's the petitioner's position that was a sweeping invasion of privacy.
I'm sorry, go ahead.
You mentioned 917 times, you mentioned the number of days and weeks, and then when we move into the drone issue, you also emphasize in the brief the length of time that this occurred and the fact that the targets would have been unaware, unlike a helicopter that was even hovering a little bit, and unlike an airplane that would have zipped right along by. So let's assume that instead of 900 plus times, let's assume that instead of 2 weeks, let's assume that instead of 3 hours a day, it was half of all of those amounts. Does that matter to your argument?
Your Honor, unfortunately, the petitioners cannot articulate a line for this court to draw. All we know is that the 900...
If you can't, who can?
We know that 917 times is surely too much, just like the drone surveillance over Miss Eddy's yard, 3 to 6 hours a day also goes too far, because unlike the other aerial surveillance cases that you mentioned, Your Honor, the nature of the surveillance was far different. The drone in this case hovered over Miss Eddy's property 3 to 6 hours a day for 2 weeks, taking dozens of continuous photographs.
Let's break down the drone issue a little bit. It seems to me there are a variety of differences one could draw on. The first is that the things we've permitted before, like helicopters flying over a home or a plane flying over a home, were sightings that were done visually by a human being. And the court seemed, in its cases, to be noting that one knows the plane is there, and one knows the helicopter's there, and so you have to know that someone can see you. Does the fact that you don't know the drone is there, and that you don't know that someone can see you in this way. Should that make a difference? And if it should, how do we articulate the rule? Is it just surreptitious? And if it's just surreptitious, well, isn't the plane flying overhead to take a look at your property surreptitious?
Your Honor, there's two reasons why that's important. First, the reason why it's relevant that the drone was practically silent and practically invisible when it hovered over Miss Eddy's property is because it shows that she had exhibited a subjective expectation of privacy. Short of not lifting up that tarp for those few minutes, there was absolutely nothing Miss Eddy could do to protect herself from the government's drone surveillance. If she had looked around or tried to hear for any sort of government surveillance or any member of the public peering into her yard, she would have been completely unaware.
What if the government said, we make this public announcement, there will be drones in the air at 400 feet, and everybody should expect that this may happen. At that point, then the public knows.
Your Honor, that may diminish the public's subjective expectation of privacy, but just because the government can do something or does do something doesn't mean that society is willing to accept the government's acts as constitutional.
How do we decide what is reasonable for society to expect? Is that for a court to decide?
Yes, Your Honor. Under this court's holding in Katz, it is for the courts to decide, but we also know a little bit about information about how the American public feels.
We have at least 4 justices who have suggested it's not a court function, that it's a legislative function. And they point to the Wiretap Act, and they point to the SCA and to other privacy legislation that Congress has passed. So the drone was in public air. And we've said things in public air, you should expect that they can see you.
Your
If
Honor,
you want to do something private, go into your house.
Your Honor, first to begin with the legislative issue, in the absence of legislation on this issue, we ask that this court recognize its role in defining the Fourth Amendment, determining its bounds, and applying it to the advanced technology that's used in
So
this case.
give me the rule. Go back to my question.
The petitioner's rule, Your Honor, is that when the government conducts drone surveillance, it must obtain a probable cause warrant if the surveillance is conducted where someone has a reasonable expectation of privacy.
And what happens when you look at our prior cases and you have this mixture here? As with prior cases, you have permissible flight. It's consistent with the FAA regulations here. As with prior cases, you have the use of publicly available recording devices. You could buy this camera, not easily, but you could buy it. But then you have this technology that I can't go buy. I don't see that mix in our prior case law. If you're aware of a case, tell me what it is, and if you're not, tell me how we deal with that added element of this mix of brand new stuff that not everybody can have and stuff that anybody who works hard enough and pays enough money can go get.
Your Honor, to begin, I have to respectfully disagree that the surveillance was conducted in public navigable airspace. FAA regulations hold that public navigable airspace is over 500 feet.
But FAA permitted this, correct?
In the certificate of authorization, the FAA approved drone surveillance over Miss Eddy's property at a height of 400 feet.
Approximately 400 feet.
Approximately, yes, Your Honor. But
What's the range of grace that approximately allows?
I'm not certain, Your Honor, exactly what approximately means, but the drone surveillance in this case was conducted at a height of 250 to 300 feet, well below public navigable airspace, and importantly...
What's the constitutional minimum threshold height below which surveillance from the air is per se unconstitutional?
Well, the last case that this court addressed on this issue was Riley, and this court found that helicopter surveillance at a height of 400 feet was constitutional, in part because under FAA regulations, helicopters can go below 500 feet. Currently,
Well, birds fly pretty low. They even come to the ground. This drone is now pretty small. I suspect in short order, the drones are going to be even smaller, and at some point might be the size of a pigeon. So pigeons can go low. That's Justice Katzmann's question, which is how does the height play into this issue?
Your Honor, it plays into this issue because of the court's precedent, and particularly in Riley, where a four-justice plurality of this court rested its decision mostly on the fact that the aerial surveillance was conducted within FAA regulations. But as Justice O'Connor explained in her concurrence, that FAA does not, it promotes air safety, Your Honors, does not promote privacy. So even if surveillance, as the plurality mentioned, in their opinion, that even if surveillance was within FAA regulations, it doesn't mean it's always going to pass muster.
Is there any evidence available in the record to show whether there was any public use of the airspace above Eddie's house at the altitude at which the UAS was flying?
No, Your Honor. Unfortunately, there is no information about public use of the airspace over Miss Eddie's home. All we know is that she lived in a relatively rural area.
And let me ask you one other question about the record, if I may. Is there any information in the record about what would have been available to the naked eye if a human being was in the drone looking down?
No, Your Honor. Unfortunately, there's no information about that in the record either, but that's another important distinction that you point out between this case and other aerial surveillance cases this court has seen before, such as in Riley and Ciarallo, where this court found it critical that the surveillance was conducted with the naked eye. In this case, the agents were parked a mile away in a truck. They could not see Miss Eddie's property, nor did they have a live feed of the surveillance. So the only thing that was constraining the government's ability to continue to photograph Miss Eddie's property, which revealed dozens of intimate moments that she shared with her house guests and even an unknown man, all of these things were captured by the drones.
This yard was only protected on three sides. One side was open to a wooded area. So she already knew that she was prone to any walker in the woods to see her. So why was there an expectation of privacy in a place that wasn't fully private?
Your Honor, that is correct that the yard was enclosed on three sides by a 10-foot-high wooden fence and on the fourth side by a natural enclosure. And lower courts have found that yards that are protected on three sides by a fence and the fourth side by a natural enclosure.
I know the lower courts have, but we haven't.
Your Honor, I see I'm out of time. May I briefly conclude?
You can answer that question.
As lower courts have explained, whether Fourth Amendment protections apply shouldn't rise or fall on whether someone spends their resources or sacrifices the aesthetics to put up an unnatural barrier on the fourth side of a yard. In this case, Miss Eddie exhibited a subjective expectation of privacy, and society is willing to accept that expectation of privacy as reasonable, so we ask that this court reverse the 13th Circuit. Thank you.
Thank you.
Madam Chief Justice, and may it please the Court, I am Kyle Singhal for Respondent. I will discuss the cell phone records, and my co-counsel, James Gross, will discuss the aerial photography. This Court should affirm because the business records of criminal suspects' public movements are not protected under the Fourth Amendment.
Yeah, let me ask you a question, if I may, about the pinging.
Yes, ma'am.
There's been a emphasis placed on the pinging and the information obtained as a result in terms of the privacy analysis. But perhaps I don't sufficiently understand the mechanics or the technology of pinging, but it appears to be sending a signal to the phone and the signal then sends back information. Is that right?
Your Honor, I think that's halfway right. I think the phone, as indicated on page 3 of the record, is already generating this signal, this record of its location.
But it's not sending it in real time unless it's asked to do that.
That's unclear from the record. It may be sending it every moment of the day. It may be the case that, as the record...
Then why would you need to ping?
In order to ascertain its real-time location at that exact second. Perhaps
Okay.
Perhaps,
But in order to do that, you've got to ask the phone to give you that information.
Perhaps, Your Honor, although it could be the case that Horizon in some form is gathering that information, but just not in a form that it could transmit directly to the law enforcement. So if that's the case, and the record on page 15 seems to indicate it is the case.
How can the third-party doctrine, though, then apply? Because here, the cell phone user is not seeking on his own or her own to have any of this information transmitted to anyone.
That's not exactly right, Your Honor. According to the customer agreement on page 15, in order even to have these location-based services, it starts on the bottom of 14, top of 15, Horizon's agreement says that these services rely on the location, the gathering, transmission, and use of this location data.
But, if I may, in the same page in the record, it states that the reason the agreement to Horizon and third parties' use of that information is to provide and improve location-based products and services. That's not what law enforcement was doing here.
That's correct, Your Honor. But
So why does the agreement help you?
It's the same as what this court confronted in Miller in 1976. There, the defendant disclosed bank records to his bank under the explicit assumption of confidence that only for limited banking purposes would the records be used. Nevertheless, because those records were no longer private, he had shared them, he couldn't claim a Fourth Amendment privacy right in those records.
But with a bank record, oh, I'm sorry.
No, okay.
We have held that the use of thermal imaging equipment outside someone's home is not constitutional because it's not something that one could see without this enhanced technology. And it's something that would otherwise remain private within the home. The fact that I'm in my home and have my cell there may be open to whoever's in the house with me, but it's private enough to be in the house with me. Why isn't this like thermal imaging? Why isn't this kind of technology that uses information from within the sanctity of my castle? Why is that not? Isn't that the essence of the Fourth Amendment to protect people in their homes?
We agree with that, Your Honor, but there's two responses as to the distinction between this case and Kylo. First of all, unlike in Kylo here, Mr. Alden did consent to broadcasting his GPS coordinates from his phone, and moreover, as Justice Rosenthal noted earlier, there was no actual tracking of Mr. Alden within his home. This is analogous to physical surveillance.
But wasn't he pinged while in Eddie's home?
Yes,
and
Your
if he
Honor.
was pinged in Eddie's home, why isn't that a clear violation of the Fourth Amendment under Caro?
Because unlike Caro and Kylo and Jardines, where the law enforcement agents saw something they couldn't have seen by means of in-person surveillance, they only saw that he was at home, which certainly they could have obtained simply by following Mr. Alden around for a period of weeks or months.
Is that limitless? I mean, they would have followed him for days and hours and weeks and months. At some point, doesn't just the sheer unwarranted, literally unwarranted, warrantless surveillance rate itself raise constitutional questions?
Yes, Your Honor. At some point that might, and if we had either indefinite, indiscriminate, or en masse surveillance, we'd have the kind of surveillance that this court warned about 30 years ago in Knotts, when it warned about 24-hour, round-the-clock, 1984-like surveillance. But that's not what we have here.
What's a ping every 20 or 30 minutes? Isn't that kind of round the clock?
Only as analogous to a law enforcement officer sitting in front of someone's house for 2 or 3 weeks. They would be there round the clock. But the catch is, this was a criminal suspect.
But that, we already at Knox suggested that that's different, because law enforcement officers don't generally do that. And so there isn't a reasonable expectation of privacy people have, that they're not going to be surveilled without a warrant.
Your Honor, we would disagree. There have been cases...
For that long a period of time.
Sure. There have been cases with, I believe, 4 or 6 weeks of surveillance. Lamping versus Walraven, I believe, was in the Sixth Circuit.
But that's a really exceptional case, and that's where the practical limit, the practical constraints come in. And what you're suggesting is that we get the benefit of no practical constraints whatsoever, and we don't have the legal constraint of the warrant. That sounds like what we fear rather than should embrace.
Your Honor, our proposed rule has 3 limiting principles in it to avoid that kind of concern. We proposed only that the government be allowed to use 1, business records, 2, records of public movements. If this GPS could see within the home, that would be different.
There are GPS tracking devices in cars that can actually listen into your conversation. I don't know if smartphones have that capacity, but it wouldn't surprise me if they did.
I'm turning mine off
And
right
if
now.
they don't, they're likely to in very short order. So let's take this principle that you're espousing. Do you actually believe that people, in giving a cell phone provider or a GPS tracking company permission to use it in an emergency, but an emergency only, really expect that the government should have permission to use it at will and to listen surreptitiously to their conversations in their home, on the street, or wherever?
No, Your Honor, you're exactly right that listening in on conversations is an entirely different story. That trespasses the Fourth Amendment to the same degree as opening someone's mail does. This court held that in Ex parte Jackson 136 years ago. But looking at the information on the outside of someone's mail has never been against the Constitution. What the public seeks here, and what petitioners seek here, is not a protection against an unreasonable search, but a heightened level of privacy. And that should come not through extra-constitutional curtailment of law enforcement.
But why? If you had surveilled this house at the moment that you pinged, you wouldn't have known if he was there. You only know it because you used his possession, manipulated it inside this home to give you that information.
We would disagree with the assessment that law enforcement here manipulated the phone. After all, Horizon was already gathering this information and saving it as their business records.
But it wasn't in the ordinary course of business. They were asked to do this. What constitutes this as ordinary course of business for the company?
According to the same customer agreement on page 15, even providing the services relied on collecting real-time geographic data, traveled road speed, and the location search queries. A subset of that is what was given here. Nothing was given over to the law enforcement, either that Horizon did not ordinarily gather or that the law enforcement could not have gathered by, albeit expensive, in-person physical surveillance. All the petitioners are going to do is have the effect of burdening the law enforcement with a cost factor here. It would cost law enforcement more to do in-person surveillance than they currently expend using cell phone site location and GPS. Again, what petitioners seek is an extra-constitutional curtailment of law enforcement power, and that should come from the legislature.
What about the ping data? Is the ping data collected by the phone company?
Yes, Your Honor. Perhaps not in the same format as it's
But
transmitted
isn't
in
that
this.
format critical if there's any distinction between real-time and historical?
No, Your Honor. The distinction is between what's public and what's private. And as long as the actual information being disclosed is no longer private, it makes little constitutional sense to apply a Fourth Amendment privacy protection thereto.
May I ask you something? Is there any legal significance, or why shouldn't there be, to the fact that the owner doesn't know that the cell phone is keeping CSI data or that it's capable of pinging? It's one thing to locate me for purposes of sharing it with some product designer. It's another to know that this is like a telephone register. There is some force to the argument that with pen registers, you know the phone company is keeping a record of your long-distance telephone numbers. But who knows that cell phone companies are keeping historical data of this type?
Your Honor, going back to that pen register case in Smith, there was actually no evidence on the record there that Mr. Smith knew the phone company was keeping record of it, and the court
Well, the court knows that it knew, common sense, every bill at the time gave you the cell phone number.
The court there looked to the fine print in the phone book to say, look, the phone book said the phone company might keep your phone number to help trace a call. Likewise here, we have a contract with some print in it that says we're going to gather this information. It's no longer...
But for very limited purposes.
Certainly, and likewise in Smith, it was there for the phone company to help you trace a call. Likewise in Miller, there the bank was keeping information under the assumption of privacy with the bank, the customer, the defendant. Even if there's a limited purpose in disclosure, it doesn't confer privacy upon the defendant. This goes back to An Lee in 1952. There, the defendant shared some information with a wired informant. He thought the guy was his friend. He snitched on him. But because he had shared the information with the other guy, it was no longer private. And what the Fourth Amendment protects is privacy.
You say on page 12 of your brief, the Stored Communications Act itself indicates that no exclusionary remedy should exist under the Fourth Amendment. Do you mean to suggest that Congress could pass any statute removing any privacy protections, and just because Congress says that there shouldn't be those protections, that should end our analysis?
No, Your Honor. It's a factor that indicates society doesn't expect the same level of privacy in metadata, in the kind of information given by CSL and GPS, as they do in call content. And under the Stored Communications Act, I believe it's 2702A, call content is subject to probable cause, whereas metadata, call records and subscriber records, are subject only to showing relevance to a criminal investigation. That's the same standard we ask this court to apply, where the defendant is the subject of a criminal investigation.
So let's deal with the emotional part of this case, which your brief doesn't really do, and which you're not doing in your argument. There is some force to the argument that today technology is invading people's sense of privacy in a way that was never anticipated before. Not only this man, but probably many, many, many cell phone users don't know the facts that I mentioned before, that their every movement is being recorded and kept, that cell phone companies can ping them and disclose where they are at will. Now, one could argue that people should be smarter, but human beings have some sense that the government won't intrude in ways that use technology to the individual's harm. Why isn't this an unconstitutional intrusion of that kind?
Precisely because
it goes against common expectations.
Precisely because of the other emotional aspect here. 2 criminals and 104 illegal guns were taken off the street. And I think that society would expect that these law enforcement officers would act reasonably in pursuing the tip, the only tip they had when they arrested the other defendant in a drug bust.
Well, but we long ago got away from the principle that if you catch a really bad guy, that's a justification of the means that you use to get there for constitutional purposes.
Absolutely, Your Honor.
That's not the argument you're making.
No, but
Then what
we've
is?
advanced a relevance to criminal investigation or even reasonable suspicion as a fallback standard, and those standards are applied today. Where the law enforcement have not an anonymous tip, as in Florida versus JL or the recent reckless driving case, where they have a credible tip. They had someone with guns.
I understand that, but let me follow up on what our Chief Justice has raised. If we accept as our case law, our binding precedent, that sticking a beeper on the underside of a Jeep is enough to violate the Fourth Amendment, even though all that lets officers do is toddle along behind them on the streets, this intrusion feels much more intrusive. It feels almost more physical, that is, pinging and getting every 20 minutes, here I am now, here I am now, here I am now, in real time, feels much more revealing.
Your Honor, I see that I'm out
Or
of
at
time.
least as much. But answer that question. Why, if the one is invalid constitutionally, how can this be valid?
You can answer it, counsel.
Thank you, Your Honor. Justice Rosenthal, 2 key distinctions between this case and the Jones case that Your Honor references. There was that physical trespass, and deciding against Jones in that case would have given license to the government to put chips in people's coats and track them everywhere. And
How about in their cell phones?
And if the government had chipped Mr. Alden's cell phone, we'd have that story. Second point, Mr. Jones could not turn off that GPS. Mr. Alden chose to use a device that could find his face on a map 24/7. If the public wants heightened protection against law enforcement use of that data, the legislature is the proper forum. We ask this court to affirm.
Thank you.
Madam Chief Justice, and may it please the court, my name is James Gross, and I'm co-counsel for the United States. When this court last confronted the issue of aerial surveillance, it reiterated that the Fourth Amendment simply does not require law enforcement to obtain a warrant to see the same things that the public can see.
How is this different than putting a cup outside outside a telephone booth
Well-
or outside someone's home. We said that was unconstitutional because people in the privacy of their homes don't expect the government to use enhancing equipment to reach into the home. So how is this drone not any different from that?
Well, absolutely, Your Honor. If we were placing a cup on the house, and like in Kylo, using technology that actually penetrated the house and led us to see inside something that law enforcement could not otherwise see.
You certainly penetrated the backyard
Your Honor, this court noted that there is no penetration
with pictures, not by a human being, but by a drone.
with just visual surveillance here, and that's the key difference here.
Just
what about-
visual surveillance?
Indeed, Your Honor, just visual surveillance, just as law enforcement could have flown a helicopter or an
Physical
airplane.
surveillance that captured intimate conduct in the backyard of the homeowner's home.
Well, Your Honor, we note that while...
Surely Ms. Eddy expected and reasonably expected some zone of privacy with respect to whatever intimate conduct she might have in the backyard of her home.
Well, two responses to that, Your Honor. First, although this court has acknowledged previously that while all details within the home are intimate, there's an important caveat there, and that's when they're exposed to public view, those details can no longer claim to be intimate.
Those firearms were not exposed to public view, regardless of Ms. Eddy's other activities in the backyard.
Well, the firearms were in fact exposed to public view when Ms. Arty pulled the tarp back from the boat.
Could that have been seen with the naked eye if a human being had been on that drone?
We argue, yes, it could have, Your Honor, with the same...
Where is that in the record?
Your Honor, we only know that the camera here took photographs at 250 to 300 feet. And if a member of the public had been flying overhead at 250 to 300 feet, they could have used that same camera to look down and take the very photographs that we have in this case.
Of course, the difference between this and our prior case law is that this was the fleeting moment. And the only reason they captured that moment is because, unlike the naked eye, there was just flying over, there was this hovering drone taking continuous high-resolution photographs.
Your Honor, to the question of whether or not society expected a drone to hover over someone's backyard, perhaps not. Just as an individual doesn't expect the cleaning van out in the street to actually be filled with law enforcement agents watching your front yard, or the drug dealer to be expecting the person they're making a deal with to be wearing a wire. The question of whether or not someone knows that surveillance is taking place has never been the inquiry underneath the Fourth Amendment. It's whether or not society has an expectation of privacy. And this court has already noted twice, in 1986 in California versus Serralo, and 1989 in Florida versus Riley, the society...
So should we be rethinking that? Meaning, no one really expects people in a plane to look down on them.
Well,
They expect people on a plane to be reading books or looking ahead of them to try to...
Protect their needs.
Exactly. My question is, what limiting principle would there ever be to the government using drones in any way it wants, anywhere it wants, if we accept your argument today?
Your Honor, we certainly
They
understand
can go to everyone's backyard. It can go to everyone's curtilage. What's going to stop anything?
Your Honor, to be clear, we're not asking for the sort of indiscriminate Orwellian state surveillance of a million drones flying overhead all the time. What we ask this court to do is limit
What's
its
going to
holding.
stop it?
As we argue
Resources?
on page 24 of our brief, Your Honor, when a drone is used to target criminal suspects for a reasonable period of time, an altitude at which the public routinely travels at, and perhaps most importantly, is operated by a human being. One human being per each drone and one drone to each human
And
operator.
these human beings who operated the drone promised in their affidavit that they would minimize personal intrusions.
And Your Honor,
And these human beings took a pornographic video of one of these defendants committing sexual acts in her backyard. So what kind of statement does that make in terms of confidence? Doesn't the warrant requirement exist to ensure that a neutral magistrate will police the police?
we don't think so, Your Honor, not in this case. Again, to the extent that Ms. Eddy had intimate moments in her backyard, any member of the public could have observed those very same activities if they had been flying overhead in an airplane or a helicopter, just as if they had been walking through the woods and been able to peer through the
You have to have very powerful binoculars.
And a lot of patience.
Well, we did have a high-power camera here, Your Honor, so again,
You've asked us to adopt this new rule, as you pointed out, and I'm concerned about where some of the limits are. So one of the requirements that you propose is that the regulations governing unmanned aerial surveillance be met. And as has already been pointed out, this was a 400-foot FAA permission, even allowing approximately, and you guys were well below that. So we have that problem. You've also asked that the rule state that this surveillance be allowed only for a reasonable period. Reasonable in relation to what? 3 to 6 hours per day for 13 days? That seems a very long time. The world was created in less time than that. So what's reasonable? Who decides?
Well, Your Honor, I'll take each of those questions in turn. First, with regards to whether or not there was a violation of the statute here. As the record reflects on page 13, 14 CFR 91.99 includes no minimum aviation or requirement that this drone must fly at.
But the authorization was limited to approximately 400 feet. Does that matter?
Again, Your Honor, I did not say anything that law enforcement couldn't fly below that. And even if it did, there's nothing in the CFR that indicates that the evidence must be excluded. Now, to your second point as to what a reasonable period of time is the majority, as Justice Scalia, writing for the majority in Jones, noted, there would be nothing wrong with 4 weeks of in-person surveillance.
But there's the practical constraint that would come in. You'd only do that for the most serious criminal investigations, and you propose in your rule that the only limiting factor be any criminal investigation. That seems quite broad.
Your Honor, our fourth limitation, though, is the human limitation, and that would impose the same sort of limitation that we impose on law enforcement, with the same with using helicopters or airplanes.
1 person per drone?
At least 1 person per drone, Your Honor, absolutely.
But wouldn't that mean we have to, if we limit it to 1 person per drone, it would be, can the person get on the drone and do it?
I'm sorry, Your Honor?
Can the person get on the drone and do it?
Just as the pilot is on helicopter or plane duty, Your Honor.
Well,
there'd be no
yes, but
difference.
the person is looking from that helicopter or plane. But the drone is not being piloted by a person, it's being guided by a person far away from the scene.
Your Honor, we don't think that there's any difference because you still have the human limitation on how often these drones could actually be used in the airspace. We do note that to the extent if there should be further limitations drawn, that should be left to the legislatures. After all, 43 states are currently considering legislation against drones, but only 13 have actually passed legislation as at the end of 2013, indicating that at this point, society wants law enforcement to be able to act more efficiently. All law enforcement did here was use a means of technology to do something that it already could do. I
think the absence of legislation at this point doesn't necessarily mean that society has reached a judgment. It's that rather in this era of new technologies, we're all struggling to figure out what the proper balance is. I don't know that you can make the assertion that the fact that the legislation hasn't passed means.
Well, at the very least, Your Honor, we should leave these determinations to the legislature to decide, particularly because this court has already noted on 2 separate occasions that society does not have a reasonable expectation of privacy from aerial surveillance within the curtilage of their backyard.
Let me ask you this. Let me ask you about the FAA's certificate of authorization. Is it your view that that certificate of authorization brings the UAS surveillance into compliance with the Fourth Amendment?
Your Honor, we argue that the certificate of authorization is actually a burden that the government imposed on itself that doesn't actually bear on the constitutionality of this. As underneath the current FAA regulations, although fixed-wing aircrafts are required to fly at least 500 feet and above, helicopters are allowed to fly far lower than that. And the fact that there's a CFR in the books related just to drones indicates that 400 feet is not any sort of minimum barrier.
But the FAA, as I understand it, please correct me if I've misunderstood, requires a good cause, for issuing a COA.
That's correct,
right?
Your Honor.
Does the good cause requirement satisfy the probable cause requirement of the Fourth Amendment?
Your Honor, we don't argue that this certificate of authorization requires the same sort of probable cause as a warrant. Again, this is a limit that the government has imposed on itself that we argue is different than the warrant requirement and doesn't need to reach the level of probable cause to issue such an authorization.
Well, let me ask you this. Let's say that we were to say that UAS is fine, but rule against you with respect to the first argument, with respect to the ping data and the CSL data? What's the remedy? Where does that leave us?
Your Honor, we would argue then that there would be no standing for to rule against Miss Eddy. All of the evidence obtained during the GPS pinging would still be admissible against Miss Eddy because she had no reasonable expectation of privacy, even if Mr. Alden did. That would be consistent with this court's opinion in Minnesota versus Carter. And as a result, even though they're co-conspirators.
I'm sorry, did you confuse the two? It was Miss Eddy's home and Mr. Alden was the visitor.
Correct, Your Honor.
Okay, so
Right.
Mr. Alden wouldn't have an expectation of privacy.
I'm sorry, Your Honor. So with regards to the UAS surveillance, I'm saying Miss Eddy would not have standing to challenge the GPS tracking, and Mr.
Right.
Alden, however, the fruit of the poisonous tree doctrine would apply to Mr. Alden.
But if I may for a moment go back to the reasonable expectation of privacy with respect to aerial surveillance. All the cases that I remember, and I didn't have the advantage of authoring any of them, all of those cases addressed the reasonable expectation in light of what we expect. And we expect to have fixed-wing aircraft routinely flying. We expect to have helicopters, but we don't expect a silent, tiny, hovering presence that has a really sophisticated camera on it, continuously focused on our backyards. And if we don't expect that, how can this be constitutional?
Again, Your Honor, the question is not whether or not we expect a certain type of technology to be used. It's the expectation of privacy. Like in Serralo, we might not expect.
Should the inquiry be different? Should it be what we expect in terms of technology? Shouldn't it be what we expect the government should not be permitted to do? That's a different inquiry.
Absolutely.
And so why would we expect the government to monitor our personal property for this amount of time, taking all of the pictures that it can and wants to?
Well, Your Honor,
Is that a reasonable expectation that people would have?
Your Honor, I would note that in California versus Serralo, there an airplane was used with a marijuana expert sitting in the cockpit and directed at this individual's backyard. Society might not expect that the plane flying overhead is a marijuana expert and is purposely flying for the sole purpose of taking photographs there with a 35-millimeter camera of your backyard.
But you expect to have planes in that space.
Correct, Your Honor. We expect to have people that would be able to look down, and that's really what the key distinction is, Your Honor.
So why do you expect a drone to look down?
Because, Your Honor, it's the same thing as having someone in the air. It's just the government doing it more efficiently.
They just got lucky at that one precise moment.
Well, Your Honor, the issue
But
of...
that's the difference, is that access to so much information that if there's anything, the government will find it.
Your Honor, we would disagree that the government just got lucky in both Serralo and Raleigh. After all, those
No,
were
you're
both
right.
targeted flights.
I agree they didn't, because they were able to capture with a fleeting view what was there in a static and long-term sense, what was exposed to a fleeting view.
Would we have a different
Not here.
case if they opened that tarp up at night?
Or kept it open.
At night.
With this court's permission, I'll take each of those in turn, if that's all right. Well, Justice Sotomayor, with regards to it being open at night, if we use technology that then allow it to penetrate the view, for example, if we actually had an X-ray device that could see through the tarp and reveal these weapons, that would be a different case, and we concede that that'd be a much more difficult case for the government to make. That would present the Kylo problem. And if members of the public don't have the same sort of technology, don't have the same night vision, for this sort of camera was not widely available, we would argue to have the same Kylo problem. Now, if the tarp was always open, we would argue that the law enforcement could always fly overhead, or they could walk through this person's woods, climb a tree, and make the very same observations that we have here. And as a result, because this is exposed to public view, there's no Fourth Amendment violation. As this court noted in Knotts, whenever something is exposed to public view, no matter if the government's using more efficient technology to observe it or not, that doesn't change the inquiry. This court has never equated efficiency with unconstitutionality, nor should it do so here. For that reason, we ask this court to affirm. Thank you.
Madam Chief Justice, may it please the court, the petitioners just have 2 points they'd like to make on rebuttal.
Can I just ask you a quick question
Sure.
that I asked your adversary? What if we were to find that with respect to the ping issue and the CSL data issue that there was a Fourth Amendment violation, but not with respect to the UAS? Where does that leave us?
Well, Your Honor, it was the information that was collected through Mr. Alden's cell phone that eventually led, that was the only link between Mr. Alden and Ms. Setti that eventually led the government to begin their surveillance over Ms. Setti's property.
So you're saying we couldn't do that? They all rise or fall together?
Yes, Your Honor, they're also tried as co-conspirators. So the evidence together was, the evidence that was collected in regard to Mr. Alden affected the later surveillance of Ms. Setti. And I would like to address, as Your Honor pointed out, some flaws in the standard of the respondent. In particular, in their standard, they said that the drone surveillance would be constitutional as long as it was manually operated. Unfortunately, the record suggests that the drone in this case was not, in fact, manually operated. It was dispatched to a, quote, pre-programmed location for a preset amount of time.
Would your argument be different if it were manually operated? In other words, if taking your adversary's view, if it were manually operated, does that change your argument?
No, Your Honor, it just points out the fact that the standard that the respondent is asking this court to adopt doesn't even apply to this case. The only constraint, there were no traditional checks on the government's ability to conduct surveillance over Ms. Setti's property. The only practical constraint was the fact that the drone's battery had to be charged after 3 hours. And as we all know about batteries and computers, by next year that'll be doubled or even tripled. So what we're asking this court to do is to find that in regards to both Mr. Alden and Ms. Setti, an unconstitutional search did occur. The respondents are asking this court to, I see I'm out of time, may I briefly conclude?
Finish your thought.
The respondents are asking this court to use cases to enthrone precedent cases like Smith v. Maryland or Florida v. Riley and apply them to this case. But their flaw is that they don't recognize how far the technology has come since the 1970s and the 1980s when those cases were decided. And so we ask this court to recognize in this case an unconstitutional search occurred to both the petitioners. Thank you.
Thank you. The court will adjourn.
All right.
I think we can give them all a round of applause. I think you can sit down. You guys can sit down. For those of you who don't know me, my name is David Johnson. This was the final exam in my class. All 4 students passed. I'm happy to report. Unfortunately, it's a one-credit pass-fail class, so we can't give them A's. My job right now is to introduce the 4 of them to you. And the first thing that struck me when I was getting ready to do this is, except for Kyle, who still has a year left in law school, they were all, including our clerk of court, they were all in the same section, and they all had Dean Morrison for con law. And I'm sorry to tell all the 1Ls and 2Ls this, but records and admissions and career services has lied to you. There is a smart section, and they were all in it. But they were section 12, and they've learned. And I'm gonna say, because Tom left the stage, so I'm gonna introduce Tom later, all right? But Tom, you weren't supposed to go. You were supposed to stay. But the 4 finalists have all sort of learned in dealing with me over the past couple of months that I really can't be trusted with a microphone in front of me. So they all wrote their own introductions. And so first I'm going to introduce the petitioners, and I'm going to do it alphabetically. And here is Olivia Jahn. And if you can clap for her at the end. Olivia went to Washington University in St. Louis for her undergraduate finance and healthcare management degree. She concurrently is pursuing a graduate certificate in health policy from the School of Public Health and Health Services with plans to practice health law in the future. Last summer, she was a summer associate at the D.C. office of Hogan Lovells and will be returning there this fall as an associate. She can often be seen around the school. I would have never said this, wearing her leopard print backpack, her leopard print umbrella, and her leopard print scarf. She also wants to thank a few people in the audience, her mother and brother, Giselle and Alexander Jahn, her boyfriend and his parents, Michael, Caden, and Greg Williams, her loving friends, especially Kate, Danielle, Maddie, and Vern, her supportive colleagues from the FCC and Hogan Lovells. She also wants to thank her fabulous partner, Amanda, for being the most supportive of them all. There's absolutely no way she could have gotten through these last few months of Van Vleck without her support and encouragement over a couple bowls of spinach and artichoke dip. Finally, she is joined in spirit by her father and her grandparents. After graduation, she will work at Hogan Lovells. Ladies and gentlemen, Olivia Jahn. Stand up, stand up. Get over there. All right, her partner is Amanda Nagrotsky. Amanda wrote the longest intro. I had to cut a little bit, Amanda. I'm sorry. Amanda had a lot to say. But Amanda's first thought was that she's a graduate of the University of Michigan in 2011. As she made the Final Four of Van Vleck, the finals of Van Vleck, she's hoping that her Michigan Wolverines will make the finals of the NCAA tournament this year. She has always enjoyed helping the underdog, so she was happy to represent the Petitioners today. In fact, she wasn't just happy. We did a coin flip. We did rock, paper, scissors to determine, and nobody cared more about which side they got than Amanda. Amanda would have been apoplectic if she had to represent the government. She wants to thank her family who are here today for their unconditional love and support throughout this competition and all of law school. She's joined by her father, Sandy Nagrotsky, her mother, Andrea Nagrotsky, and her sister, who looks just like her, Emily Nagrotsky, and who graduated from GW Law in 2011. Her dad is an attorney. Obviously, her sister's an attorney, and her mom is a court reporter, so law runs in their family. She also wants to thank her friends for all of their support and understanding throughout this competition. She's been AWOL for a while preparing. Last but certainly not least, she wants to thank Olivia for being an incredible partner and friend since the first day of this competition. There is no one else she'd rather work with than Olivia. And then I don't get this last joke, so I can only read it as written. Amanda hails from Nassau County. Olivia is from Suffolk County. Together they represent Long Island, but it will be funnier if I say Strong Island, and I have absolutely no idea what that means, but God bless you. All right, Amanda Nagrotsky. The gentleman did not quite have as much to say, but they had a few things to say. Jim Gross. Jim, next year, he will be clerking for Judge Sandra Ikuda on the Ninth Circuit. Actually, Judge Ikuda was a Van Vleck finalist judge a few years ago. He's not yet accepted a formal position after his clerkship because of his firm's policy, but he does have an offer to return to Sullivan and Cromwell following his clerkship, working either in their New York or London offices. He's the editor-in-chief of the GW Law Review, and he also won the first-year Moot Court competition when I got to judge him. So I did something right. He wants to acknowledge some of his family that's in the audience. His parents, Jim and Michelle Gross, his Nana, which I thought was very nice. Hello, Nana. I actually met Nana. I met Nana at lunch. Marianne Pepsney, his good friends Bhavik Patel and Kelly Bayer, his cousins Meredith and Gretchen Smith. He also noted that Kyle thought it would be funny to note that Jim is not recognizing his girlfriend because he doesn't have one. And we'll just end on that note. Ladies and gentlemen, Jim Gross. And last but certainly not least, Kyle Singhal is the 3L evening student of the group from Dallas, Texas. Kyle speaks fluent French and Spanish, is a member of the Law Review, and competed last year in the Andrew Kurth Moot Court Competition National Championship, winning Best Oralist. Kyle is joined by his wife Emily, his parents, his brothers Jackson and James, and his sister Maya. And not to be outdone, James wanted to point out that if you all look at your tickets or programs, you will notice that Kyle's tie isn't straight. So there you go. Ladies and gentlemen, those are our 4 finalists.
Please have a seat. All of you were here to see the extraordinary performance of all 4 of these students. So, if you never understood that judging was hard, at this moment you should understand how tough it was for us to pick the winning team. It is always, for me, a delight to be a part of a moot court like this one. And a delight because you give me hope about the future of our profession. You keep me inspired to do what I'm doing because I know that there are young people following who have the same passion and excitement and love of skill that I do. And that's the hope you give me, to know that we will be continuing to better the profession because you're out there. You 4 are amazing. There is no way that I was as polished as you were when I was in law school. So imagine, you have a lot of hope for the Supreme Court. I didn't have either the skills or the presence to do what you have done today. Tough case. Petitioners, you had the hardest of arguments, and very little case law in your favor. I said at my lunch to the dean and the 2 lovely professors I was with that my concurrence in Jones, remember, I was only 1 of 9. And so it's not really law that can help you. But you did a wonderful job with a tough legal position. And respondents, you did an equally lovely job. You brought out very, very well the sort of essence of our cases and relied on that. That's, what you're supposed to do, and you did it skillfully. It was very hard for us to pick the winners. Harder legal issue, more precedent, and each of you skilled. There was only a slight edge in the winner, and if the edge was in anything, it was in the consistency of theory that the respondents had in their presentation. And that may have been a flaw inherent in the side you guys picked. I'm very, very proud of the fact that you took the harder side. That shows a lot of courage and a lot of gumption. But we have selected as the best team Kyle and Jim for the reasons I've just said. But you should all leave with your heads held very high and very proud. This was an extraordinary presentation of legal skill. Thank you. Bosa. Well, I don't even know if they give you a trophy for this, but they'll tell me. If not, I do know that we have some gifts for you. And so I think, yep.
Hi, I want to thank you all so much for coming today. What an amazing final panel. We just wanted to say thank you specifically to our very esteemed bench. This has been an absolutely great experience for all of us, and we have a token of our gratitude for each of you. For Judge Rosenthal, I think you have your present coming. Yes, we have a GW Law umbrella and a personalized signed copy of Justice Sotomayor's memoirs, My Beloved World.
Thank you, and I want to in particular thank not only the law school for giving me this great opportunity, to thank the students for giving me a chance to learn a great deal, but to my fellow panelists who are amazing jurists, amazing people, and for the great good fortune of being able to take a piece of one of them and to have it as a reminder not only of what inspiration looks like on the page, but also of a wonderful afternoon. Thank you all, and congratulations to all four of you.
For Chief Judge Katzmann, we also have a GW Law umbrella and a signed copy of Justice Sotomayor's book.
Thank you.
He got his personalized copy almost immediately after it was published.
And of course, finally,
And
we have a token
the
of
paperbacks
gratitude
are
for
now
Justice.
available.
Oh, I'm sorry. We have a token of gratitude for Justice Sotomayor. We know that she's a Yankees fan, so we have for her a bottle opener made from a bat used in a Yankees game.
I also just want to thank everyone as well, as Judge Rosenthal said, and what a great honor it's been to be with this fantastic panel and to be with Justice Sotomayor, who is just a treasure in every possible way. There are people in this world who achieve great things, but they're not great people. And this one is a great person.
I paid him to do that.
Not enough.
Thank you, Lee and Bob, and thank you all for making this such a special afternoon for us. Congratulations to everybody. You won today.
And I'd just like to take a moment to thank everyone from the GW Law Moot Court Board and the school who made this possible. All of the competitors, not just the four up here, but all of the competitors through all the rounds did an amazing job. All of the local practitioners and judges who came and judged all the rounds up until today. And there are three specific people on the board that I would like to thank. Of course, Derek and Tom, who you've been introduced to as the co-chairs of the competition, and also the Vice President of Internals, Laura Simple, who helped put all of this together. Thank you all so much for coming. I hope you enjoyed it.